Hello, everyone. Welcome to one of our quarterly webinars here at McGuireWoods in connection with our Hospital and Health System Working Group. Today, we're going to be talking about regulatory actions and M&A activity impacting hospitals and health systems. I see on the attendee list many friendly faces, so many of you already probably have heard me speak in the past. My name is Kayla Marty. I'm a partner here at McGuireWoods, and I co-lead with a number of my colleagues our Hospital and Health System Working Group that focuses on many of these same transactional and regulatory issues that we're going to talk about today. But for those of you that aren't as familiar with our firm, we wanted to give a little bit of background on McGuireWoods and some of the initiatives that we have so you can put them on your radar and hopefully are able to participate in future events. So McGuireWoods is a national law firm. We have 1,000+ attorneys across the country, and we always are one of the largest healthcare groups specifically in the country and have a strong focus on provider services business as well as facility services with respect to hospitals and health systems. You likely have seen us at some point during thought leadership or different conferences that we host, and we really hope you're able to join us for more of these remote events like our webinars, but also some of our in-person events that we host are throughout the country. So just a couple of things to be aware of as you all book your calendars for this year and also are looking at opportunities across the country. So the first is coming up very soon in Chicago on May 8th and 9th. We host our Healthcare Private Equity and Finance Conference. We have a health system panel this year talking about the intersection between health system innovation and also health system partnerships, particularly as the footprint is expanding for ambulatory care. And then another in-person large conference will happen in September 25th and 26th this year in Charlotte, North Carolina, where I'm based. This is our Healthcare Finance and Growth Conference. It will be very focused on providers. There will be a number of panels that focus on hospital and health system issues. There also will be a number of panels that focus on physician practices, imaging facilities, surgery centers, many things that probably all of you all are impacted by every day. So we hope to see you there. We'd love to have you. And then over the course of this year and into next year, we'll continue to have healthcare pop-up events in different cities across the country. We've held them in Nashville, Denver, Chicago, other areas. We'd love to see you at one of those. If you're interested, please feel free to reach out to any of the panelists. Like I said, we'd always love to have you. If you haven't interacted with our platform before, you'll see that you'll be able to see our slides as we speak, and we'll advance through those as we go. There's also a question and answer box. So if you have any questions as we move through, please include your question in those question and answer boxes. We'll do our best to get to the questions during the presentation or at the very end of the presentation. If for some reason that we don't get to your question, we will reach out following the panel to close the loop. So do feel free to include those. And at any time, feel free to reach out to any of the panelists to talk about the issues that we're going to be speaking about today. And the last thing, for those of you that I see on the call that are attorneys, we are offering CLE in connection with this event. You should have included your bar number when you registered. If you did not, or if you are unsure about the CLE structure for your state, please feel free to reach out to our planning team that was on the invite that you received. We're happy to help you in any way that we can. So with that, I'd like to introduce my fellow presenters. You'll be hearing from Gretchen Townshend, which will be talking about many of the regulatory settlements, developments, things to know. And then my colleague Nathan Young, who will be talking about many of the transactional components that impact hospitals and health systems today, specifically some new things that have come out with respect to antitrust, the FTC. I'm sure many of you are familiar with the non-compete information that has really surfaced in the last week or so. And then I'll wrap us up talking about joint venture opportunities and opportunities with respect to innovation funds or venture funds, many of which you all may have had an opportunity to create within your own systems, or there may be people that you partner with that are on the phone today. So with that, Gretchen, if I can just turn it over to you to start with the very first part of our agenda, which is on regulatory actions and settlements, specifically Stark and different FCA issues.
Great. Thank you so much, Kayla. So we're going to start by looking at the numbers. Fiscal year 2023, which ended in September 30th of 2023, was a very active year for FCA settlements and judgments. Record-setting, both in the terms of number of settlements, 543, as well as in dollars received by the government related to those settlements and judgments, $2.68 billion. That brings the total to an excess of $75 billion in False Claims Act recoveries since the False Claims Act really became an avenue to do so in 1986. While those numbers are not uniquely inclusive of healthcare, healthcare is a huge component of it, has been for several years and continues to be. Nearly 70% of the settlements amounts from last year, $1.8 billion, were healthcare related. We're going to dive in the coming slides into some of those settlements and recoveries and what the underlying conduct was and how those things can be instructive for your organizations in a minute. But it's important to note that these False Claims Act recoveries are not just stark and kickback, which is what we healthcare lawyers talk a lot about. There's a lot of areas where False Claims Act claims and actions are brought about. The key areas of conduct that were highlighted by DOJ and OIG are listed here on the slide. Submission of false or inaccurate information about health status of beneficiaries as it relates to Medicare Advantage claims, among other Medicare and federal health care products. Unnecessary services being rendered or substandard care, claims for those kinds of services. The actions of providers and other entities in the opioid epidemic, certainly seeking action against those folks. Kickbacks, which we'll talk quite a bit about. Fraud in the purchase of goods and services, as well as pandemic fraud, COVID-19 funding, and the like. So moving on to our first example, which I am sure you have all heard about, the Community Health Network settlement with DOJ for $345 million, the largest FCA settlement premised on stark law violations since 2006. So this was a big one. And this is not included in the numbers I just mentioned because it occurred after fiscal year 2023. So what were the underlying actions here? Well, the claims were that physicians were compensated in excess of fair market value. They were paid bonuses based on patient referrals for hospital services. And interestingly here, Community Health Network did have valuations, but the allegations were that those valuations were based on false information provided to the valuation consultants. So having a valuation in your file is not sufficient if the underlying facts for those valuations are not based and premised on the actual reality of what's going on there. There's also allegations that CHN ignored warnings from the valuation firms regarding the consequences of potentially overcompensating physicians. So a huge settlement of this nature brought by a whistleblower in this case, and certainly there is a corporate integrity agreement that the government imposed on CHN associated with this settlement. As those of you who have been to these webinars and are generally aware, corporate integrity agreements last long into the future, require various reporting obligations to the government, and impose very specific obligations on the organization as it relates to its operations. For example, requiring that the organization get fair market values for certain physician compensation relationships, or possibly all of them, having a monitor in place, having a special reporting committee tracking different kinds of relationships and the like. So every corporate integrity agreement is a little bit different, but what they all have in common is that they last for quite a long time, can be incredibly expensive for an organization to comply with, but ultimately provide additional and continued oversight by the government as to the actions of the potential of the entity subject to that corporate integrity agreement. So so what, right? So why do we care about these kinds of settlements? And again, we'll go through a few of them here in a minute. Well, I think there's been pretty media coverage that suggests that CHN was really trying to structure these physician compensation arrangements to be competitive in the market, and compensation arrangements are complex, right? There's a lot of components to that, and so ensuring that that hospitals can compensate their physicians fairly and appropriately, but also be competitive when they're trying to recruit and encourage folks to stay within their system and their organization, that can be a fine line. But certainly making sure that those compensation arrangements fall within the bounds of fair market value, as well as the requirements of Stark and Kickback, are going to create the best protection and really are required, right, given the strict liability nature of Stark law. Couple other examples, and these did fall into the fiscal year 2023 bucket of similar types of allegations, right? Improper compensation arrangements with physicians, $5 million for Sibley Hospital, $5.7 million arising from compensation plans for 44 physicians for Massachusetts Ioneer, Covenant Health Care System with a $69 million settlement related to improper financial relationships with physicians. So there's lots of examples of these out there, and certainly we're seeing them every couple of weeks. There's another one announced. So having really good processes in place to ensure that your financial relationships are appropriate and compliant, both from a Stark and a Kickback statute perspective. Another example here, the New York Presbyterian Brooklyn Methodist settlement, $17.3 million. This, again, relates to payments to physicians based on the number of referrals the physicians made for services, in this case at the hospital's chemotherapy infusion center. There were also allegations here of failure to adequately supervise, so that the services were not essentially supervised and thus billed appropriately. $17.3 million is a pretty hefty settlement amount, but here, as distinguished from the CHN example, these were claims and issues that were discovered by New York Presbyterian themselves. They found out about these issues, they discovered these issues, they raised their hand, they went to the government, they disclosed them, and they do not have a corporate integrity agreement, right? Their processes and procedures in place prevented ongoing conduct, and then they, again, went to the government to disclose these actions, which certainly mitigated the penalty. Again, a lot, but could have been more, and then did not require the imposition of a corporate integrity agreement, as evidenced by the quote there from the U.S. attorney who was prosecuting the case. My next example here, the Penn State Health settlement. Again, this one was self-reported by Penn State, and here we're not actually talking about payments of compensation to physicians. So we're pivoting a little bit to the action that was discovered, and this was the submission of claims for wellness visits that were not supported by the medical record. These claims, as you can see from the slide, spanned 7 years, right? It was a significant chunk of time. Penn State uncovered these improper claims, went to the government on October 3rd, made the self-report, and had it settled less than 6 months later, which is an unprecedented speed. If anybody of you have engaged with the government, that's a very quick process. But again, going to a fine, a hefty fine, right? $11.7 million. That's a significant amount of money, and this is refunding of those claims that were not supported. But again, no corporate integrity agreement, given at least in part that these were discovered through Penn State Health's internal processes for review of claims and the like. Key takeaways here, right? It is important, as it relates to this particular settlement itself, making sure that your medical records are fully documented, that all your claims are compliant with Medicare rules, making sure that items that are submitted are for services that are medically necessary, actually rendered, and the like. Doing periodic reviews of those things to see if there are inadvertent failures within the system. And as you are doing that internal discovery, if you find any issues, going to the government, right, and trying to get those things resolved quickly and for without the imposition, theoretically, of a corporate integrity agreement after the fact. Couple other examples here, again, more recent. The Little River Healthcare, in this case, it was brought against specific executives, not the hospitals themselves, but these were payments that were paid to physicians to facilitate kickbacks, allegedly, the allegation for lab tests referred to Little River, and the payments were really through MSO entities in which those physicians owned. The hospital comptroller, CFO herself, was charged for false certifications on the cost reports because some of those cost reports contained claims and information related to these kickbacks. And then there were several other defendants found guilty of a kickback scheme. So again, it isn't just physician compensation relationships directly. This particular one is a good example of situations where the payments were going through an intervening entity, allegedly knowingly flowing to physicians who made those referrals as well. But these types of arrangements can create pretty significant liability, not just for the systems themselves, but for individuals within the systems who are involved in the arrangements. My next example here is the settlement with Detroit Medical Center. Again, False Claims Act, anti-kickback violations, and in this case, quote-unquote benefits to physician referral sources, but not in the form of compensation or cash or payments, rather in the form of NPs, PAs, and the services of individuals at below market or no market costs to, again, induce physicians to send their patients to Detroit Medical Center. The folks who had the benefit of these individual APPs were selected based on their large number of patient referrals. So the key takeaway here, kickbacks can take a lot of forms. It's not simply physician comp. It's not even the example we just talked about where a direct payment for a referral in a one-for-one type of a way, but also when a hospital or health system provides benefits, non-monetary benefits to referral sources in a way that is intended to induce or reward referrals. Sometimes that line is tricky, sometimes that line is hard, and what sort of benefits are permitted within the hospital, for example, for physicians who are at the hospital and the like. And so it isn't always a black and white answer, but it's an important question to be analyzing for your clients, or if you are executives with your lawyers, so that you are making sure that there is very clear coverage in STARK or kickback, so the safe harbors and exceptions to protect the conduct in a way that prevents scrutiny and potential claims against the system. So now I'm going to switch gears here a little bit from the traditional fraud and abuse claims and settlements and judgments. There's other stuff going on out there, right, that you all are probably aware of but need to continue to monitor. And the example here summarizes the catheter fraud scheme that's been going on for the last couple of years that really remained largely undetected because the value and the cost of the catheters is so small, $8 or so per catheter, but that folks out there got the names of potential beneficiaries, were ordering the catheters unbeknownst to the providers, unbeknownst to the patients. massive increase in catheters were billed to the Medicare program over these 2 years, and costing nearly $2 billion in DME revenue that was unusual, unexpected, and potentially fraudulent. What's interesting about this scheme, if you will, which again is still being investigated, we don't have a ton of information about it, but it really came to light from hospitals and from hospital ACOs who were questioning where some of the shared savings that they were expecting were going, and really digging in and looking under the claims and in the information to discover that their covered lives were having a bunch of these catheters that the patients had never heard of or never seen or anything like that. So again, it's an example of the importance for hospitals and health systems directly, and those who have insurance products or ACOs or other things, to be paying attention and looking for these kinds of issues that might not be readily apparent, even if through no fault of their own, right? Again, just being vigilant. So now I'm going to switch to the Stark Law self-disclosure process. 176 self-disclosures were resolved through the SRDP process this year. That is a record. The prior was 103, so a whole bunch of them this time. And you can see from the slide that there are, a record number of settlements, and we have the numbers listed over there. In addition to the record number of settlements, the average settlement amount is a record. Again, if you look at the chart there, the $12 million in the aggregate on Stark settlements. The ranges on the settlements here, $26 to $548. So we're not talking massive dollars on these self-disclosures on the Stark side. With an average of $71,000, the third lowest average on record. And it's really just evidence that the Stark Law self-disclosure process, things are moving more quickly. It is certainly showing CMS is anxious to get through some backlogs. We have a number of clients that have submitted them with deals or other things that have been waiting for a very, very long time to have them resolved, and we are starting to see the backlog clear. Also, some of the changes to Stark a couple of years ago, which called into question whether some of the disclosed actions were in fact improper. Some of the softening of the Stark laws has led to a whole bunch of retractions as well. And so again, I think the takeaway here is that CMS is actively and quickly trying to get through the backlog and resolving some of these issues much more quickly than they have in the past. And then the last slide I just wanted to hit very quickly, and we're not going to go into great detail on these. There are McGuireWoods alerts and or upcoming webinars on all of these issues. So certainly we are available to answer questions about them, but they are really there's sufficient information for them to warrant their own fulsome discussion. But just an example of what is a very, very active time of rulemaking for federal agencies right now, many of which have significant impacts on the healthcare providers and hospitals specifically. So very quickly running through the updated compliance plan guidance that came out in November of last year, which isn't massive changes to what has been in place for a long time, but provides additional guidance and recommendations for providers of all kinds, as well as higher level folks at board members and whatnot, making sure that everybody has a hand in the compliance activities of the organization. In mid-March, the OCR and FTC sent out the warning letters about the privacy and security risk for online tracking technology and providing guidance for hospitals and health systems and other providers to consider when contemplating the use of various tracking apps and the implications of HIPAA on those tracking technologies, which again have become much more prevalent and have the potential for sales of patient PHI and the like, which can certainly implicate HIPAA. The FTC non-compete ban, which came out last week, April 23rd, and the implications of that to providers of all kinds across the country, including the implications on nonprofits and whether or not there is an application, which, again, the non-compete ban is a whole nother topic of conversation, but certainly something that everybody needs to be monitoring, aware of. The Section 1557 updates that came out last Friday, which effectively are swinging back to the Obama era of those provisions and then some, with the requirements on providers to implement policies for non-discrimination and limited English access, appointing a 1557 compliance officer and performing training, technology and algorithm obligations to make sure those are not triggering discriminatory practices, implementing a grievance process, and providing notice to patients that these things are available. April 22nd, the minimum staffing rules issued by CMS, the national minimum staffing level requirements for LTACs and skilled nursing facilities. And just 2 days ago, the FDA regulation of hospital labs and treating those laboratory developed tests as medical devices. So again, there's a lot to each of these, each of which could warrant their own webinar, but just some high level examples of stuff that's coming fast and furious, and you're all monitoring it, we're monitoring it, and trying to educate people as they're coming out, recognizing some of the concerns. So what do you do? With all this that I just said, what do you do? Ultimately, I think it's a couple of key takeaways. Hospitals are not the primary focus of the government right now. It may not seem that way based on everything we just said, but it doesn't seem to be the case, right? It's not that they are, government regulators are out and looking for and after hospitals. But because of the services you provide and because of the regulated industry in which you operate, when there is an issue, they tend to be pretty costly for obvious reasons. And so I think it is important that you all don't feel targeted, but vigilant, right? It is certainly important to continue to monitor your own activities, make sure you are looking at your own operations to ensure that you are prepared in the framework of the increased government enforcement efforts. Keep working to build your programs. If your organization has not reviewed the new compliance program guidance and your senior leadership is not aware that it's there, they should be. It is time to kind of go through that and make sure that your compliance programs comply with the new guidance, and that everybody knows that they do and have a stake in this compliance environment. And then again, making sure your board and governing the C-suite and the board, everybody has a stake in this, and that they should be involved and understand and aware. And if you discover something, figuring out what is the right approach to mitigate the risk associated with an inadvertent fault. So with that, I will turn it over to Nathan, who's going to talk maybe a little lighter topic about some of the M&A activity that isn't quite so, glass half empty. Nathan?
Great, thanks, Gretchen. I don't know if the lighter topic of antitrust is what we'll start with, so I don't know if I'll fulfill your promise there. But on the transactional side, like I said, one of the biggest areas of development we've seen in the last year or so has been the increasing levels of antitrust scrutiny across the board. So this has been both the federal and state levels and across all types of healthcare transactions. At the federal level, the Biden administration has repeatedly expressed concerns about consolidation in the healthcare space, and has even specifically mentioned the hospital sector in the context of its impact on employee options, rural access to care, and the like. In fact, as evidence, the healthcare consolidation is top of mind for federal regulators. Just a couple months ago, the FTC, DOJ, and HHS together issued a request for information seeking public comment on this very topic. And then as Gretchen mentioned too, in a related space, the FTC also as we're all aware, recently issued a final rule potentially banning many non-competes in the employment-related space. So the point really here is just that the federal government has become increasingly active here in the antitrust space, and especially as it relates to healthcare specifically. But again, it's not really just segregated to federal scrutiny. We're also seeing a lot of states getting very involved as well. For example, an increasing number of state legislators have recently passed mandatory pre-closing notice requirements for certain healthcare transactions. These laws typically apply to transactions with healthcare entities that meet some sort of revenue or asset value or similar threshold. And they generally require parties to notify the state's AG of the proposed transaction, and those pre-closing notice requirements can range anywhere from 30 days to even 180 days. So these are areas where they can add long lead times and need to be accounted for early in a deal's timeline. But even in states that don't necessarily have these pre-closing notice requirements in place, we're seeing them contemplate adding such requirements, but we're also seeing increased activity from state AGs who may see larger profile transactions in the press and then seek additional information to try to assess any potential antitrust implications. So across the board, federal, state, across any types of healthcare transaction types, we're seeing a lot of scrutiny here. So as an example, we wanted to quickly look at the proposed John Muir tenant transaction in California. Here, John Muir sought to acquire a California medical center from tenant, but in November 2023, the FTC sued to block the deal, and they alleged that the deal would threaten competition, increase prices, diminish quality and access to care, and harm workers. These concerns were driven in the most part by the FTC's view that the hospital's two primary local competitors were already run by John Muir, and the deal would have allegedly given John Muir control of over 50% of the local market. And shortly after the FTC suit, the parties abandoned the deal, citing concerns surrounding the cost and disruption of this litigation. And the key takeaway here really is just, again, healthcare transactions, but especially regional transactions, are facing increased antitrust scrutiny and enforcement. So one option for addressing this antitrust concern is potentially looking for cross-market partners. So an example here is just a few weeks ago, Risant Health, a newly formed subsidiary of Kaiser Permanente, acquired Geisinger Health. This was notable because it was a cross-market deal between California-based Kaiser Permanente and Pennsylvania-based Geisinger Health. This was Risant's first acquisition, but it plans to acquire many other regional health systems around the country, and their ultimate goal is really to bring these regional health systems under a single umbrella to try to create a multi-system, cross-regional, value-based care organization. And in particular note, Risant communicated that its goal was really to use the scale it would build and the cross-market collaboration to develop a tech-supported platform that could improve outcomes and reduce patient costs. So again, focusing on those types of things, we'll get to in a minute some takeaways, but really the improving outcomes and reducing patient costs, by focusing on that, that can help alleviate some potentially antitrust concerns. And again here, while cross-market transactions may not make sense in every situation, they may still provide a way to build scale, transfer knowledge and technology, while still potentially reducing the regulatory risk that may come with regional deals, as we saw in the John Muir example. But again, we just want to reiterate, not saying that regional deals are impossible. In fact, they're still very much prevalent, and they do make sense in many cases, but they just require strong preparation and diligence to pass that increased regulatory scrutiny. So a couple good examples of regional deals that have recently closed. Both of these closed on January 1 of this year. First was the St. Louis-based BJC Healthcare, ended up merging with Kansas City-based St. Luke's Health System to form a regional system in Missouri. And on the same day, two Wisconsin-based hospital systems merged to form a regional system in that state. So again, these things are still prevalent, they still happen, but they just are going to require an increasing amount of preparation and diligence to try to comply with the regulatory scrutiny that we're seeing. So what might that preparation look like? Well, first, all deal members should be aware of the antitrust landscape from the very beginning. So this impacts what and how things are communicated. It will impact, as we talked about with some of those pre-notice requirements, it may impact your deal timeline. Making sure all deal members are aware of the landscape that they're dealing with from the very beginning is key. For example, you don't want to be in a position down the road where you're getting close to closing and you realize at the last minute, oh my goodness, this deal is subject to a 90-day pre-closing notice period, and now closing has to be pushed back. Along with educating everybody up front, also relates to establishing a good communication plan from the very beginning. And this isn't just about establishing that plan, it's also effectively communicating your plan to all stakeholders to make sure everyone's on the same page. So again, I mentioned this a little before, but there are some things you do want to focus on, or you may want to focus on, and things you may not want to focus on. And so I think primarily you want to emphasize these, benefits of the transaction, whether that be to local workers, whether that be the improvement of quality or access to care, whether you're now able to offer more services in the area, and even potentially investment impacts that are unique to you as the acquirer that other potential partners wouldn't be able to achieve. And those examples could be anything from a specific cultural fit or alignment of purpose. It could be a buyer's track record of success. It could be, again, you have certain service lines that would complement well with the target. Any of those things would be a little more beneficial potentially than the things on this do not focus list, which are avoid saying things like we're going to boost market share, we're going to reduce competition or increase our bargaining power. Anything that might be considered anti-competitive would be a quick red flag in the antitrust space. So overall, the key here is really taking action from the very beginning. That could be taking, again, protective measures, which would be engaging consultants so you're aware and everyone on the deal team is aware of exactly what you're getting into. There are other potential avenues. So there's myriad ways to structure deals, and they extend well beyond the traditional hospital-to-hospital or system-to-system approach. And partners can take many different forms. So one example we wanted to highlight was the Bon Secours Mercy Health and Compass Surgical Partners strategic partnership that was announced last year. So the health system and ASC management partner are working together to expand outpatient surgical care. So they plan to develop over 30 ASCs over the next few years. This will range pretty much all over the eastern half of the United States and may potentially expand into new areas where the health system isn't currently. In fact, they just opened their 4th ASC in South Carolina just a few weeks ago. Really, we just wanted to highlight this as an example of a potential way to structure a partnership. So again, just like regional deals are still very prevalent, obviously hospital-to-hospital and system-to-system transactions are still a way to do things, but there are also a variety of other creative opportunities for partnership and for growth in this space. And so we just want to make it clear that hospital leaders should be open to unique opportunities, but again, we want to remain cautious of the evolving regulatory landscape that can come in some of these less proven areas. And finally, this awareness of regulatory scrutiny does not stop at closing. It continues throughout the life of the go-forward arrangement. So specifically, parties to a transaction have to closely monitor and abide by any post-closing obligations they agree to in the deal. So for example, in 2019, HCA Healthcare acquired Mission Health for $1.5 billion. But 4 years later, in December 2023, the North Carolina AG sued HCA, alleging that HCA failed to comply with post-closing obligations that were in the purchase agreement. So it's at issue here were provisions in the agreement that required HCA to continue providing certain services at certain levels at Mission for 10 years post-closing. In its suit, the North Carolina AG alleged that HCA cut or reduced certain service lines, which would be a breach of the purchase agreement and also allegedly caused a decline in quality of care. Since the suit was filed, local cities and counties have become involved, and federal regulators have cited the hospital for violations that risk the hospital's federal funding. Now, it should be noted, HCA disputes the allegations, continues to work with federal regulators to address the findings, but the point still remains that there's not only increasing regulatory scrutiny about deals on the front end, but also deals on the back end as well. Scrutiny here is not really limited to just the deal itself, but continues onward. Consistent with what kind of Gretchen previously talked about, regulatory scrutiny and enforcement is up across the board. And here it shows that it's extending to not even deal-related, but also post-closing obligations the parties may have agreed to. So in sum, on the transactional side, these considerations are what we view as critical for successful growth. First is paramount just to get your house in order. Do it in advance to minimize any potential issues and unforced errors. And then be prepared for heightened scrutiny or filing lead times, as we talked about a few times. Again, it's key to be aware of, and then also plan for and communicate a plan for how you're going to navigate the increased regulatory scrutiny that you're going to see as you go through these deals. You want to make sure that stakeholders are informed and that they're aligned from the very beginning and consistently kept up to speed throughout the deal. Additionally, as we kind of just talked about with the strategic partnerships, just be creative in how a deal may be structured or how a partnership may come together, and be open to new ideas. As we discussed, new ideas could range from anywhere between, are you thinking of a regional partner versus a cross-market partner? Are you thinking of a merger versus just a JV or strategic partnership of some form? And then considering any alternative or direct investment opportunities that may come up. And Kayla will talk a little bit about some examples of that here in a minute. And then finally, just how do you follow through on your commitments? Like we just saw, the regulatory scrutiny doesn't stop at closing, it extends throughout. And so being cautious of what did you agree to, what did you promise, and how do you accomplish those promises going forward is key as well. So with that, I'll turn it over to Kayla just to talk through kind of what some investment opportunities may look like going forward.
Absolutely. Thanks, David, and thanks everybody for joining with us. The last topic is going to be on innovation funds and general growth-focused investments. Innovation funds are something that have been emerging significantly among the health system group and then also partnerships between health systems and other capital providers. At this point, people call them different things. Some people call them innovation funds, some people call them strategic development departments, some people call them venture funds. You're going to hear them in a lot of different facets, but there's a theme overall. As systems get larger, there's a greater increase of need to build in-house solutions to particular problems, and a lot of these funds have arisen as a result of that. You'll see here we've included just an example of some of the organizations that have founded venture funds. This is just a handful of 30, 40 plus that we know of in the market, so it very much is an area of emerging interest, and we think will continue. There are some thematic goals, no matter what people call these funds, that we see them developing and then we see them really focusing in on. So first, many of them are exploring emerging technology and innovative care delivery models. So they're really looking to be able to shape the way technology is developed in order to respond to specific goals in their region or specific goals in their own system. The other element is we have seen a huge focus on investing in businesses that improve health equity overall. For example, I was at Becker's healthcare conference last week and was talking with a couple of women about their funds investments in maternal health, specifically African-American women and maternal health outcomes, and they were investing in technology to support that through their innovation fund. So that's just one example of some of the areas that we're seeing a focus on health equity. The other component that we see that is not exactly venture and is not exactly innovation, but is being targeted through many of these funds is expansion of the ambulatory footprint of the system overall. We're seeing investments in ambulatory surgery centers, investments in imaging facilities, investments in retail care settings. So I think all of those are areas that people view as a real ability to grow, and they're being invested in through these arrangements. The other thing that's very interesting about them is they both compete with or invest with capital providers in many situations. It is undeniable that there's been an extreme growth of interest between private equity, venture funds, family offices, things of the like in the healthcare space. And many people have their own opinions about that component, but it has been undeniable. And health systems are in many instances using these funds to either invest directly in another private equity fund that then in turn is investing in different healthcare investments, or to joint venture with venture funds or private equity in particular pieces of technology or particular pieces of provider services businesses. So I think that that's something we continue to see, and the nimbleness of those elements of the organization and those funds make it really possible to make those investments. The other thing is it really tests external intellectual property development. That's been an area of focus to find a way to respond to very specific and tailored technology and intellectual property needs of an organization. So we see that pretty frequently across funds from a thematic perspective. And it really gives an opportunity for clinical providers to craft what the technology looks like if they're investing in these early stage companies. And then last but not least on thematic goals we're seeing is it does give unique revenue opportunities to the extent that these investments are then replicated across many other health systems. It provides a very unique revenue stream for the organization. So there are both unique opportunities for these funds and unique challenges. These are just a couple of opportunities that we've identified in connection with working with a number of these funds and also working with a number of companies that are taking investment from these funds. So like I said earlier, it provides this opportunity to invest in very early stage businesses. That means that you can craft the technology, you can have clinical input into the technology, like we're seeing that very significantly with certain types of AI products. The ability to put in data that's very specific to your region, your organization, can make them even more useful than if you were to have to develop them from an outside party. It also, in many instances, provides a lower cost entry point than developing these products independently by the organization. So that's been a real opportunity place, even though we'll talk a little bit about the challenges, and this creates a few challenges as well. One of the most interesting things that I have seen with respect to these funds is the ability to have growth opportunities across multi-players in the healthcare market and multi-investor alignment. So we've frequently seen healthcare IT companies, private equity funds, health systems, and providers all collaborating together through these innovation funds or venture funds or enterprise funds in order to better the clinical community and also better outcomes for patients. So that's been very interesting because we've seen several investments by multiple health systems in one product. We've seen several investments by private equity-backed companies and health systems in one product or company. And then that really brings in multiple insights, multiple ways of delivering care to make a really great product for patients and ultimately clinical care delivery. So that is a very interesting opportunity that isn't present in many other situations. The other component that we've really seen a demand arising in is data. People need data in order to deliver technology-driven clinical outcomes. And so we see many of these companies that are somewhat early stage, and even in the more developed space, being able to combine these very nimble companies with respect to data, like I said, AI, other components, with large platforms like health systems to really propel forward the combination of the clinical and provider side of the business and the technology and other data side of the business. So I think there's a real opportunity there that people are focusing on, and the ability to roll that out has been very interesting. That means, however, there are always unique challenges. So this is just a couple of the challenges that are facing innovation funds and health systems generally with respect to these type of investments. First is developing a strategy for innovation investing. Most systems, probably for many people on this phone, are not inherently set up from day one for innovation investing or venture investing or private equity investing. And really the strategic investing component is crucial in order for it to be successful. So we're going to talk a little bit in a minute about just some key takeaways, but one of the biggest takeaway here, and also one of the challenges, is being very disciplined in the investments that people are making and making sure that they align with your system's goals in such a way that it is intentional and is producing the outcomes that you all want. So if there isn't great alignment internally on what those goals are and what those strategies are, it can be really difficult to implement that strategies. The other component is sometimes an outside third party is necessary to deliver on the strategies that you all have as an organization. And so that has to be taken into account, and that can be a challenge because it adds an additional party, it adds an additional stakeholder to have to deal with this issue as on the front end. So those are all things to take into consideration for your particular funds or your strategic development arms. The next component is the target companies or the investments that you're making are often charting completely new territories. whether they be providers that are charting new territories, for example, in telehealth or other care delivery issues, or to be technology companies that they are literally the first of their kind providing a particular service. So we are in health systems and in lawyers supporting health systems and business people supporting health systems. We're used to having fairly clear and defined rules with respect to where we operate. There are regulatory challenges that exist in many of these companies that innovation funds and venture funds are investing in because they are often well beyond where the law has developed. So that is a little bit uncomfortable, and it's something that always has to be navigated. The other component is it will likely be in an area that your system does not independently have expertise. And that's the reason you're going outside the system and making these investments. So figuring out who's going to monitor the particular investment and who is going to ensure that that investment aligns with your strategic goals is very important, but it can be a challenge at first. The last component is perfection may not exist in the initial investment. In many instances, these are companies that are going to be much less developed than your system is developed. And so there's often additional investment, additional refinement that's needed following the investment in a way that a technology or a care delivery model isn't necessarily going to be plug and play on day one. And so that can be a real challenge that the system has to work through. So in line with what Nathan and Gretchen have been talking about, so what? What do we do with this? How can we be prepared to really guide internally our investing, our innovation funds, our venture funds? These are just 10 key takeaways that I would always keep in mind, and I'm going to punch through them really quickly here. Number one, like I talked about earlier, know your strategy. From the outset, don't be sucked into this system is doing this or that system is doing that. Know your goal, know your strategy, and then make investments to go after that, including size targets. You may not be in a position as an organization that you're prepared to invest in early stage companies, and that's okay. Different people and different organizations are set up for different things. You may want to focus on growth investments that expand your ambulatory footprint, but are with more well-defined and well-developed companies. Like I said, know your risk tolerance too. Stay very disciplined. If a company is very cutting edge, there's not a lot of familiarity in the regulatory space, and your organization is quite conservative, that may not be the right fit for you. And so just know that risk tolerance going in and constantly evaluate it. Also be ready to admit when an external investment partner may be a value add, whether that's a physician practice, whether that's a strategic management company, a private equity fund, another venture fund. In many instances in this growth-minded phase, having an external partner can be helpful, and just know when that's a good opportunity and don't be afraid to look for those opportunities. The next is engage the right advisors, whether it be accountants, attorneys, strategic advisors. You may not have the internal expertise within your organization for this type of investing. It's very unique, it's very nimble, and so don't be afraid to look externally on that as necessary. And be flexible. During the transaction process, these are going to be a little bit of different investments. The expectations of the other party may be different, the timelines may be different, so go in and prepare your organizations to be a little bit flexible, not in the goals, as I described earlier, but in the process itself. Another component is be prepared to move on. When making these investments, both from an innovation perspective or a venture perspective, there may be scenarios in which you get into diligence or you get into other components and you realize it's not a good fit, and be ready to move on from those investments when that's the case. And also be prepared for the level of operational involvement that it's going to require. Like we talked about earlier, there is some companies that are going to be more developed than others and some that will be requiring more operational expertise than others. So whatever that level is for your particular target, plan for it, make it part of your strategic objectives, and make sure it's resourced appropriately so the investment really can be all that you hoped it would be. Again, with this, be patient. It is something where many of these companies and many of these organizations will not be plug and play on day one. And so those expectations are going to need to be set internally appropriately and then constantly revisit. and continue to make plans to drive growth and overall value creation. And this goes along with the being disciplined component. Figure out how it's going to fit into your organization. Don't let it be a silo. And then make sure once it is succeeding that it's being rolled out across the board so that it can be as successful as possible and meet the goals you intended it to. And then constantly reevaluate the integration and opportunities investment in your system. One investment may be a great jumping off point for another investment, and so that's something to be aware of. That's an important component of innovation funds and looking at these specific types of investments. So with that, I think we're basically at time. We really appreciate everyone joining us in connection with this webinar. We will be having other webinars as a follow-on, particularly to the different points that Gretchen mentioned earlier. In the next couple of weeks, we will be having a webinar that is very specific to the new non-compete rule that was published by the FTC. Please be on the lookout for that. We also have a program going, which is a hospital roadshow. So to the extent that your organization wants to learn more about any of these individual topics or wants to present in a lunch and learn format with respect to CLE, we're always happy to come to you or do that virtually. If that's of interest, please reach out to Gretchen or I. We've been doing that for a number of our clients, and they've been in contact and they've been well received, so don't hesitate to reach out. Thank you all so much. We really appreciate you, and we hope you have a great afternoon.